We handle a lot of cases against the cruise lines here at the firm, and that's actually something that I used to do when I worked on the defense side. One of the firms I worked at did primarily cruise line defense work for the three major cruise lines and their subsidiaries. But we handle all types of cases against the cruise lines, and this ranges from people falling off the ship, sexual assaults, unfortunately, slip, trip, fall type incidents, over service incidents. But I wanted to talk a little bit about those slip and trip type fall incidents because there was a dangerous condition there on the ship, because that's one of the things we run into again and again. I get questions all the time from potential clients and clients who have injured themselves by slipping or tripping, by just saying, well, can't we just go and have a big trial and talk about how what they did on that day was wrong? And I get that sentiment, but unfortunately, one of the things that we have to deal with before we even get to trial on those types of cases is the notice issue. Now, pursuant to the federal law that we are bound by when we're prosecuting these cruise line cases, is we need to show before we actually get to a trial that the cruise line was on notice of whatever dangerous condition we're claiming. That could be a slippery floor, a transient substance on the floor such as water or some other type of grease, an uneven step, bad lighting in a walking area, or anything. I mean, the list goes on. Use your imagination. A couple of the ways that we can prove this are showing that the cruise line had actual notice of it. Now that's where we uncover that the cruise line or an employee at the cruise line actually knew that there was the substance on the floor, or that the step was uneven or broken, or something like that. A lot of times we don't have the benefit of that, so we have to rely on showing that the cruise line should have known that there was something dangerous going on with whatever area of the ship we're concerned with. So that's where the discovery process comes into play. In the discovery process, that's where we take depositions of different employees of the cruise line or different crew members. We get documents regarding prior incidents that the cruise line has had on the ship, documents regarding safety meeting minutes or internal memoranda, and that's where we try to show that based on prior incidents that have occurred, internal things the cruise line has discussed, or something else that we find, that the cruise line should have known that there was something dangerous going on in this area. And then hopefully, if through that discovery process, we come up with something that's able to get by this notice requirement and get the case to trial.